3, 2, 1.
So this is an episode of Scott Talks Law, and welcome once again to another episode of Scott Talks Law. And in this episode, we're going to talk about the relationship between international law and the national law, or municipal law. So international law is that law that deals with the relationship between sovereign states. So this is the law that governs the sovereign states, that regulates the conduct of sovereign states, that is concerned with the state practice, the practices of states. So international laws are concerned with the sovereign states, whereas the national law is the law that deals with the relationship among individuals within a particular nation. So international law is that law that deals with the relationship among individuals within a particular state or a particular nation. So this is the law that regulates the rights and obligations of individuals within a particular state or a particular nation. So the difference is that international law is concerned with the states, whereas the national law is concerned with the conduct of individuals, regulating the rights and obligations of individuals within a particular state or a particular nation. So understanding the relationship between international law and the national law, there are two theories that were developed to explain the relationship between international law and the national law. And these are the Monist theory and the Dualist theory. So these two theories were adopted to explain the relationship that exists between international law and the national law, the municipal law. So according to the Monist theory, the Monist theory explains that international law and national law are simply derived from a basic component of knowledge known as law. So these two systems are derived from a single entity of law. So a single entity or a single body referred to as a law. So international law and the national law are simply a manifestation of a single body of knowledge referred to as law. They are explaining that these two legal systems were derived from a single entity referred to as law. So they are just a manifestation of a law of law, and explains that these two legal systems, international law and national law, operate within the same sphere and deal with the same subject matter. Both international law and the national law operate between the same sphere. So because they deal with the same subject matter, these two systems, international law and national law, can come into conflict. And when they come into conflict, international law is said to prevail over the national law. So according to the Monist theory of law, they give more superiority to the international law than the national law. So international law is more superior over the national law. And according to Hans Kelsen, who is a Monist positivist, he says that international law says that international law is more superior to the national law, and this is a consequence of his basic norm or his grand norm. And according to Hans Kelsen, the grand norm is that basic principle upon which all other laws gains or obtain validity from. So these two systems are systems derived from the basic norm or the grand norm, according to Hans Kelsen. So Hans Kelsen says that international law is more superior to national law, and where the conflict arises, the national courts shall apply international laws. So international laws are superior to the national laws. Professor Hans Lauterpage, who is also was a judge in the International Court of Justice, also asked that international courts or international law is more superior to the national law because international law deals much with human rights, the law that concerns more, or the law that deals or solves a lot of issues that deal with the human rights, and also as tests from common human rights lawyers in the international plane. So according to him, more human rights lawyers can also affirm that international law is the one that is able to deal, is at the best position in dealing with the human rights issues as opposed to the national law, more than what national law can do. National law is only concerned with the individuals, and it does not really deal with the issues of human rights. So according to Professor Lauterpacht, or hence H. Lauterpacht, who is a judge in the International Court of Justice, international law is more superior towards the national law. And also the monist naturalist theory also give their own view concerning the relationship between international law and the national law. And according to the monist naturalist theory, they say that these two systems, the national law and the international law, are simply a manifestation of a simple entity which is referred to as the law of nature. So these two systems are derived from a single entity referred to as the law of nature. And according to the monist naturalist theory, international law is more superior to the national law, and they adopt a hierarchy which explains the superiority of laws, such that the most superior is the natural law, followed by the international law, and the national law comes third. So according to the monist naturalist theory, there must be a hierarchy of laws, and according to this hierarchy, the natural law is at the topmost, followed by the international law. Then the national law, the municipal law, comes third. So that is the relationship. That is according to the monist theory of law, that international law is more superior, and these two systems of law, they deal with the same sphere, they operate within the same sphere, and they deal with the same subject matter. So the dualism theory is another theory that explains the relationship between international law and the national law. And dualism rejects that notion that international law and national law operate within the same sphere. So according to dualism, international law and national law are two different legal spheres, and each system operates within its own legal sphere or its own plane. And each system is so independent from the other, such that international law is concerned with state practice or the conduct of states, whereas the national law is concerned with regulating the rights and obligations of individuals within a particular nation or a particular state or municipal. So dualists such as Triple define international law as the law that deals with the conduct of states or regulating the conduct of states, and he also defines national law as the law that regulates the rights and obligations of individuals within a particular nation. Triple also says that the international law is concerned with the subject matter of states, and the national law is concerned with the subject matter of individuals within a particular nation. So consequently, an individual may be denied a right under the national law, which is permitted under international law. So the national court shall apply the national laws, and the international court shall apply international laws according to the dualism theory. So likewise, and a right may be unlawful within the international laws, but that act may be lawful within national laws. So national courts might find an act to be lawful within its particular territory, but those acts may be unlawful within the international law. And that was evidenced in the case of Jones versus Saudi Arabia, where the United Kingdom permitted immunity for alleged acts of torture that were unlawful within the international law. So those acts of torture were so unlawful within international laws, but we find that according to dualism theory, those acts were permitted within the territory of the United Kingdom. And a government may be performing its functions lawfully within its territory, lawfully, even though these acts and the acts of this government may call for questions in the international laws, or the acts may call for international responsibilities. So you'll find that there are particular acts that are permitted within a nation that are not permitted in the international law. And it was seen in the case of United Kingdom confiscating the embassy of France within its territory. It was so lawful within its territory. It was permitted. It was seen as not as something legal, but the same was not legal or lawful within the international laws because they were violating the Vienna Convention on Diplomatic Relations, 1961. So those acts of confiscating the embassy of France were illegal in the international law because they were against the Vienna Conventions of Diplomatic Relations. So these two legal systems, the international laws and the national laws, can come into conflict because they concern the same subject matter. And when they come into conflict, the national courts shall apply the national laws in resolving those conflicts, and the international courts, such as the International Court of Justice, shall apply the international laws in solving those conflicts, because these are two different legal systems that operate within different spheres. So in the case of R versus MC Kerr, Lostein says that the rationale of this dualist theory was to prevent the executive from imposing laws to citizens without domestication. It was to prevent the executive from just coming up with laws that were undomesticated. And according to Lostein, for international laws to be adopted within a particular country, these laws must be domesticated. They must go through the National Assembly to be approved as domestic laws to be used within a particular nation. So Lostein said that these laws must be domesticated. They must go through the National Assembly, the legislature, to be approved so that they can be used within a particular nation or a particular state. Another view was taken by Lord Bridgham in the case of R versus John. And Lord Bridgham says that customary international crimes were not crimes under the national laws. Customary international crimes were not crimes under international laws, and international laws shall not permit customary international crimes within its own territory. And Lostein brings these exemptions to this dualist theory that rights and obligations or duties are an exemptions to this dualist theory of law. The rights and obligations of individuals are an exemption to this dualist theory according to Lostein. So for this international laws to be permitted within a particular territory or a particular nation, they must be domesticated by going through the National Assembly to be approved, to be accepted as laws of a particular country. So you find that the difference between the dualist theory and the monist theory are that the monist theory operates within the same sphere, but the dualist theory these two laws do not operate within the same sphere. They operate within different spheres. And the similarities between these two different theories, dualism theory and the nationalist theory, are that they all concern with the same subject matter. They all deal with the same subject matter. And under monist theory, whenever a conflict arises, under monist theory, international law is said to be superior to the national law, and international law shall reign superiority and shall be considered in solving those conflicts. And under dualist theory, whenever a conflict arises, international law shall not be used, as in the case of monist theory. Whenever a conflict arises under the dualist theory, the national courts shall apply the national laws. International courts shall apply international laws in solving those conflicts. So Hans Kelsen, monist positivist, and Professor Lauterpacht were the ones that say that under monist theory, the international law is more superior to the national law. And also under the monist theory, the monist naturalist theory, these are just laws. The national law and national law are just components of the legal basic law of nature, and the legal basic law of nature is the topmost of the hierarchy, followed by the international law, then the national law. The summit is the law of nature, and the national law comes third. So that is about the relationship between international law and the national law. So that's the end of my episode, and have a nice day.